Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Donald Coleman presiding. While court is in session, there will be no talking, no sleeping, no chewing of gum or reading any material. Thank you.
All right, this is case number 22-243052. This is Max Chambliss Sr. versus Victoria Park Homeowners Association. Today is a time set for a pretrial conference regarding this matter. The court previously issued a scheduling order in this regard. Your appearance for Max Chambliss or Max Chambliss, whoever, please indicate your presence here at this time.
Good morning, Your Honor. Michael Hayes on behalf of the plaintiff, Mr. Chambliss.
All right, Mr. Hayes, your P number, if you will, for the record, sir.
75419.
All right, thank you, counsel. Good day to you, sir. For Victoria Park Homeowners Association, your appearance at this time, please. All right. Looks like I have an indication of Robert Meissner. Counsel, have you spoken with the other side here?
Alan Penskar is here on behalf of the defendant. He's here. He's probably having a difficult time unmuting his phone.
Got you. Let's see if we can help him out there. Thank you, counsel. And Mr. Penskar, if you're hearing me, you can go ahead and unmute, and you also can hit *6. That will assist you with unmuting as well.
Okay. I hit the unmute button. Hopefully that works now.
We can hear you.
Okay. I apologize. This procedure's a little bit new for me. So for the record, I'm Alan Penskar, attorney from the Meissner Law Group representing the association.
Thank you, counsel. Your P number, if you will, for the record now.
Certainly, P 41759.
All right, thank you, Mr. Penskar, and good morning to you. Well, I did give some time for discovery in this matter. Mr. Hayes, why don't you go ahead and update me? Where do you see things are at this point?
Thank you, Your Honor. We still need to amend the complaints. In part, we were hoping, so here's what happened. We filed discovery requests shortly after our last status conference, and the association filed objections to it. Their objections were based on the fact that they were waiting for us to amend the complaint. However, we want the documents before we can amend the complaint so that we can figure out exactly what our potential claims are. And so we've got a little bit of a disagreement in that regards. We haven't filed any motion yet. We were hoping that maybe the court could help us out here today, or alternatively give us some additional time to file a motion to compel. But our position is that we really need the documents in order to determine what our client's potential claims are, and would save judicial resources, you know, if we didn't have to file a motion to compel and then file a first amended complaint and then potentially a second amended complaint based on what we received from them in discovery.
All right, have you received any motion for a more definite statement or any defense motion relative to the complaint?
I don't believe so. I don't think it was in their answer when they were moved to, this was initially a small claims action, and so it was removed to this court.
All right, thank you. All right, Mr. Penskar, go ahead and update me. It sounds like the case might have gotten stuck a little bit. If there's not a motion for a more definite statement, then the order for discovery should lead to the exchange of information regarding this matter. It doesn't seem like that's happening. Mr. Penskar, it's on you now. Go talk to me, sir.
Thank you, Your Honor. The answer is very simple. It was filed in the small claims. We removed it, as Mr. Hayes said. The one thing Mr. Hayes left out, however, is that his senior counsel, Mark Demarest, talked to me about this issue back in December. I brought up the idea that they needed to file an amended complaint to expand upon what they're seeking, because the use of the affidavit form in small claims court might have worked there. But in truth, the claims they're making were always something that needed to belong in the district court. So I talked to Mr. Demarest, and I'm looking at my email with him from December 26th, where he specifically says, we will be filing an amended complaint. Yes, I could have gone after him after they had not done that for a while and filed another motion with the court. But I took it on my belief was that they would follow up on that, and they haven't. And I've talked to them about that, but it hasn't occurred. So yes, they do need to file an amended complaint. Certainly I could file another motion in front of that. It wouldn't have made much sense, because they'd be doing the same thing and they would be filing whatever they want. He's got claims here that, he's bringing forward. We have a generalized idea of what he's going for, but we certainly don't have any specifics. Mr. Chambliss is a resident of the association, and he does tend to send numbers of documents to the association demanding certain documents in return. And I've dealt with some of them over the last few years, and that's fine. And so he's entitled to file this case. The whole point is we don't know exactly what the case is. So if they would amend their complaint, then we can move forward and we'll get to the substance of the case, which is essentially what Mr. Hayes was alluding to, but not getting to, which is that these documents that he's asking for are really difficult to ask to supply if we don't know what the case is about, and we need to be able to defend ourselves. So if they would just file an amended complaint, which I think they could probably do in a matter of 2 or 3 pages, and the case would go forward from there. We both would know what the landscape is.
All right, Mr. Piscar, I've heard you. Listen, gentlemen, you kind of mutually, you kind of practicing law for the other person. The fact of the matter is, without an order in place to stop the advancement of this case, then the advancement of the case should not be stopped. If there is a request for documents and discovery that are discoverable items, those items should in fact be turned over. It would be good, of course, if the lawyers could get together and work out something whereby they agree to the sequence of things. But if there has been discovery requests made, then unless those discovery requests are oppressive in some kind of way, then the discovery requests should be met. And so that's my concern. Granted, a 60-day period of discovery, I'm okay with certainly extending that. But this has gotten bogged down over, I think, a little bit enough. It doesn't matter whether whether you put 1 foot forward or the other foot forward. One way or the other, it does seem to be that in this matter that there's ultimately going to be some type of amendment of a complaint. There's probably going to be an answer and then a supplement to an answer as well. But that doesn't stop the parties from exchanging information that may relate to the events that are alleged. And as Mr. Pinskar has indicated, Mr. Pinskar has indicated in his statement that the defense knows some of what this case is about. So exchange of information is a critical part of this. So, gentlemen, we're stuck with 2 smart lawyers waiting on the other lawyer to do something. So how do you propose to go forward with this? I could simply order that the discovery be turned over. Obviously, the case is not going to significantly advance until the issues are narrowed. And one of the ways that those issues are narrowed is with an amended complaint, if that is what is anticipated. Mr. Pinskar?
Well, I have one response to that, Your Honor, is it's a little bit like the cart before the horse. The discovery should not be documents that are sought as part of the cause of the action. discovery should be,
I don't like to interrupt, but let me interrupt you there.
Okay.
It's really, the cart before the horse is not a good analogy here. Sequentially, there may be a preferential way of proceeding in this regard. There is a lawsuit that has brought this matter before the court, and the court issued its order based upon that lawsuit and based upon a response that was filed to that lawsuit that allows the parties to exchange discovery. The parties are in order to do so. And while you may approach this in a different sequence than Mr. Hayes and vice versa, without a stipulated agreement or some type of order between the parties to do it differently than what the court has ordered at this point, then you really don't have that. Now, I'm willing to kind of move past that. Let's see what we need to do to go forward with this. There's some potentially really smart lawyering going on here, but I'm not going to let that. I'm not going to let that tie this up. Let's figure out what we're doing here now. You got a discovery request. That information should be turned over unless there's some substantial objection that the discovery is burdensome or not, that there's a proportionality issue or something along that line. Otherwise, it should be turned over. Now, Mr. Hayes, when is your client going to file an amended complaint? You certainly, the law says that the court will say that you can amend as justice required, or the court should allow amendments as justice requires. And it seems like in this case, if we're going to go back and forth, justice is going to require that you be allowed to amend and then amend again and then amend again and so on and so forth. We're stuck somewhere where we don't have to be stuck, is what I'm saying. How soon can you get the discovery out, Mr. Pinsker?
okay, I have no problem with doing that. It just has to be a two-way street on this, and that's what bogged us down so far. I'm certainly will follow what Your Honor has just set forth.
All right, absolutely, Mr. Pinsker. Mr. Hayes, do I need to put a timeline at this point on the filing of what is known to occur, and that is an amended answer? Let's do it this way: 14 days to turn over the relevant discovery request, and 14 days thereafter to file any amended complaint. So I will set the matter. I'll leave discovery open. I want both sides to have the full benefit of being able to explore information, and I'm glad to see that there are lawyers involved that kind of know how these things go. So that's a good thing. So what I'm going to do is I'm going to bring the case back before me, gentlemen. I'm going to set it on the I'm going to set it on the 29th of March, 3/29, 23, and that's going to be at 9:45 a.m. I'm going to order that with regard to the exchange of information, that by the 15th, any discovery request be complied with by 2/15/23. Once that's submitted, I'll give until the 1st of March for the reply for an amended, for any amendments of the complaint that may be requested in this matter. And then I'm setting it, as I said, for the hearing on the 29th. I suspect, gentlemen, that you will need to file other documents. Mr. Pinsker will want to file an answer to the amended complaint and so on and so. So I know that this is a case that will be in motion, but I want to take another look at it on the 29th of March, 2023. Let's see what at that time. All right, gentlemen.
Will the court submit the order, or do you need us to prepare it?
I will issue an order with the information that I've just provided, with the things that I've just ruled upon. And gentlemen,
Okay.
always know that you can file a motion at any time and set it for a hearing on a date that is coming up before you, before the court. So you got 3/29 is your next date to come in front of me. If you wish to file a motion dispositive or otherwise, I will hear it on that date, so long as you make sure that the other party has at least 10 days to respond to the motion prior to the court date. So again, if it's even a motion for somebody in this position, any type of motion you wish to file, I will hear it on the 29th. All that's required is that you give a 10-day window for the opposing party to respond to it and set it on for hearing on March 29th. I'll hear it on that date. That doesn't mean you have to do that, but you, that is always available in front of me. If you have an upcoming court date, as long as you give notice to the other party, that gives them at least 10 days to respond, I'll hear the motion on the next action. All right, gentlemen, I'll get the order out to you right away. Mr. Pinsker, any questions at this point, sir?
I guess just one last housekeeping question on exactly what you were just pointing out. Can we also file motions on non-meeting dates with the same 10-day notice period? For example, the time period between now and March 29th is essentially 2 months. So if after the first 2 items are added, which is the discovery goes out and the amended complaint is filed, there's still a block of time before we would see you again. Is that a period in which we can file these motions that come up on the same 10-day period?
Yeah, the ideal here is, Mr. Pinsker, unless there's an emergency motion, you would not be able to get back in front of me prior to the 29th. So everything is governed around March 29th at this point. In regard to the future motions, then the court will set a date on those items. This is just to give the attorneys the opportunity that if there's something that they'd like to get heard right away, and it's coming up that needs to be brought to my attention, then you have a mechanism getting that heard on the 29th without having to wait till some future date. But certainly this does not cut off the parties' rights to file motions into the future, not at all.
Okay, I was thinking almost specifically about an SD motion or a partial SD at least. Yes.
And you
Okay.
you have the 29th as an operational date that you could do something like that. But if that's not something that's set for the 29th, then when you come to me on the 29th, you're going to tell me that, Judge, I've got a SD motion that I wanted to get heard as soon as possible, and I'll set that up so that the parties can get right back in front of me to be heard on that motion.
Okay, thank you.
All right, absolutely. All right, anything, Mr. Hayes?
Nothing else from me, Your Honor.
All right, thank you, gentlemen. I'll get an order out to you right away. All the best on this. I'll see you soon.
Thank you.
All right, thank you very much, Your Honor.
Good day to you.
Thanks.
The court now calls case number 22-194-774. This is Beaumont Health versus LaPorche McGowan. The matter is before the court, set on after a status conference. I have a notation indicating that I was awaiting an order to be submitted to the court. Your appearance at this time for Beaumont?
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
Thank you, counsel. Good morning to you, sir. Do I have LaPorche McGowan on the zone here to say something at this time?
Literally 5 minutes on myabc.com. And alarm.org reports that 9 out of 10.
Your Honor, what you stated, if I may, what you stated is exactly correct. My only issue is we've attempted to email this defendant and also mail her a copy of the consent judgment, and she has not returned it. I thought maybe we may have had the wrong email address. I know we do not have the wrong mailing address because, of course, we got service. I defer to you. I could attempt to try to reach her again. We've called her a group of times and tried to email her.
All right. I would go ahead and submit the document under the 7-day rule, counsel. And it seems to me that at the last hearing, Ms. McGowan indicated that she had reached an agreement regarding this matter.
She did, and she is making her payments. She just hasn't returned my agreement. Would you like when you say under the 7-day rule, which of course I will do, would you like that to be a default or submit my consent unsigned?
Submit the consent and simply put on the consent on the record on consent on the record that was on the 18th of January, 2023.
Thank you, Your Honor. I will do that.
All right, thank you. And you have the email address to send it here, correct?
Is it still Carmen?
Yes. Yes, sir.
If I could just say it so I get it right. I have carmen.banks@36districtcourt.org.
That's correct, sir.
Thank you. We'll get it to you today. Thank you.
Thank you, sir.
Have a great day.
Likewise to you, Mr. All right, the court now calls case number 18-158-266. This is credit acceptance versus Cortez Robinson. The matter is before the court on the defendant's filing of objections to a writ of garnishment. It looks like the garnishment relates to a Crystal Robinson Insurance and Financial Services Incorporated. The record should reflect further in this matter that a judgment was entered by default on the 3rd of October 2018. That judgment is for $15,291.78. Counsel, your appearance for Credit Acceptance Corporation, please.
Judge, may I please court? I'm Attorney Richard Rusin, my bar number 35222. I'm the attorney of record for the plaintiff. And today I am the respondent to defendant's objection to a wage garnishment.
Thank you, counsel, and good morning to you. I'm looking now for Cortez Robertson. If you're on the Zoom, Cortez Robertson, the matter is set on for 10 o'clock a.m. It is 10:30. Mr. Cortez Robertson. All right, is there anyone on the Zoom related to Mr. Robinson? I see a Bonnie Price. Why are you here? Trying to see if that person may in any way.
No, I was with the Chambliss Victoria Park.
All right, got you, ma'am. Thank you for letting me know that. Appreciate it. So it looks like defendant has not shown up on this counsel, and the objections indicate defendant says I'm unable to afford, and no other basis was set forth for the objection. It might have been a veiled effort to seek relief in the way of some type of payment plan or reduction in the amount being garnished. But defendant is not here, so on its face, the objection to writ of garnishment surely does not provide any basis upon which the court could conclude that the objections would be valid in any way. Mr. Wilson.
Judge, may I please court? The record you have made is succinct, and I adopt it by reference. I ask that you deny the objection because defendant is not here to prosecute it. Therefore, I rest.
Thank you, counsel. The court will find the objections invalid and will sign an order consistent therewith, releasing any funds withheld to the plaintiff, and the garnishment will continue.
Thank you, Judge. Thank you, Judge. Plaintiff rest.
This one right here, I said right here. Judge Henry Johnson brought this up. She said it should be assigned to you. If so, can you let me know? And then I can change the judgment. I said I wasn't gonna touch it. I'll be right back.
All right. Get it. All right, Ms. Price, you're gonna dismiss yourself from here.